I like words. I like learning new words. And I remember long ago getting into the legal profession, learning about the word dilatory. It's fancy, lots of syllables, but it's super important because a lot of people use dilatory tactics in law or in trials. And I'm getting the sneaking suspicion that one Bryan Kohberger and his legal team might be using dilatory tactics. It's like a delay. It's an effort to span something out. And the reason I think that is because his lawyers have been making all sorts of efforts to slow down the process. They want more time to look into the, let's say, grand jury process to see if the indictment's even a good one. And then they ask for discovery again and again and again. Could very well be because they're not getting what they should be getting. But I do wonder about the dilatory tactics and if that's what's happening in Idaho right now. I know somebody who knows way more about this than I do. It's Andrew Cherkasky. He's a criminal defense attorney and a former federal prosecutor. He's with me now live. The reason I ask this is because the state of Idaho has had to go on the record and say, we object, Ann Taylor, who's the lawyer for Bryan Kohberger, we object to your effort to stop the proceedings so that you can do more of a looky-loo through all the grand jury process. Is this normal or is this dilatory?
Well, I think we're still in a normal territory. We're only a little over a month from the indictment that happened back in May. And what the defense is doing at this point is they're doing everything I think they need to do to protect every angle of the case, to make sure that they're getting all of the documents and all of the time they need to review those documents and file their motions. Now, do I think that they're taking tactics that are going to help Mr. Kohberger in the end? I don't, but you don't.
Well, stop there, because
Yes.
I was going to ask you about this whole business about the state having to come in and object to Ann Taylor's, requests for additional discovery on the grand jury. I have not heard this before. Maybe it's just because I'm not as much as skilled as you are, but I have not heard of a robust fight against the grand jury process and the indictment itself. Is that rare, or is this just like throw every piece of spaghetti you can?
I think it's relatively rare, and I actually had to dig into it a little bit today as I was prepping to be here. I think it's what they're indicating they're going after is the makeup of the grand jury. So was there a problem in the selection or the people? Were there biases in the grand jury members? If they perhaps have some sort of insight into that we don't know, maybe they're onto something. But realistically, we rarely see that happen. Grand juries are almost untouchable in terms of what happens there. They're relatively secret. There really is very little attack to be had. The Supreme Court hasn't said much about it. So it's an interesting tactic. It's early in the process. I don't see it going very far.
It gives us something to talk to because there's a gag order and we can't get all the goods.
Well, there's so much we want to know about the case and so much about those details that we don't know right now. So we're looking at all of the little details along the way, aren't we?
Is there ever? It was really technical the way this battle, this sort of sparring, it's very technical. I'm not going to bore everybody with it, but safe to say you didn't write it down properly. That's the objection that the prosecutors have. You didn't give us a sworn statement. It was in a footnote. It shouldn't have been a footnote. And that's all very technical. I assume the judge is going to say, can we move on with it? No, we're not going to stay the proceedings for this.
I think that's what the judge is going to say. We're going to know this basically by this time next week. On the 26th, there's a hearing coming up.
27th, I think.
27th, excuse me. On the 27th, there's a hearing coming up, and they're going to discuss all of this. And I think this is going to be the judge calling balls and strikes, saying you need to hand this over to the defense. Defense, you don't need this much time. It's going to be relatively ordinary in that regard. And that's what the judge is there for, when the sides can't agree. And I'm sure that Mr. Kohberger doesn't want his attorney agreeing to random things with the prosecutors here. He seems to have a fighting spirit about him. So this is where the judge comes in and calls balls and strikes, as we like to say.
Let me ask you this last question, and it's the one I like to continue asking until I get the final answer from the judge on this case. 31 days until the prosecutors have to be on the record as to whether they're going to seek the death penalty in this case. Do you see any way around them not saying absolutely?
I can absolutely not see this going any way but capital. There's about a dozen factors that are considered in Idaho in taking cases to go capital, multiple victims, the way in which the crime was committed, and many more considerations. This hits many of those, the majority of them, in fact. And so when you have that many on the table, I can't see a rationale for why you wouldn't in a state that allows it. Otherwise, it's just a political move with prosecutors who don't believe in the death penalty.
What is the death penalty? Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.